Friends, we are starting now. Today is 162nd Friday group meeting. The speaker is our beloved senior advocate Siddarth. A few details about Siddarth. He cleared his law from National Law School of India University at Bangalore. Then he enrolled bar in 1997. He designated as a senior advocate in 2019 by this honorable court. He appeared many criminal cases and civil cases also. So today's topic is the Unlawful Activities Prevention Act 1967 and National Investigation Agency Act 2008. Interplay between the two legislation. Very glamorous subject, sir. In fact, when pandemic started, on the day he supposed to address, because of sudden closure of this entire Delhi and Supreme Court, we cancelled that. After that, we trying to chase. So thank you very much. So we'll go by one introduction, sir. Quickly, I am G.Seshagiri Rao.
Rahul Agarwal. Praswan Kumar Mishra. Amit Pratap Singh.
Manjeet Jha.
For us.
आपको जान
Please, quickly.
G.D. Remand.
Yeah, please.
Gita
Yeah, good. Roma, you are not. Okay. Yeah. Backside this, sir. For our purpose actually. Karpagam sir here, no need to have a retire.
I will give my introduction to
बोल दिए
हीरा सिंह रावत.
होगा back side anybody there? Now we can start, please.
you shall put in the pocket.
Yeah, I'll put it. I'll just, sorry.
Friends, and as Seshu mentioned, I'll do that. Friends, as Seshu mentioned, I was to address this gathering just on the day, I think, when the restrictions came into place in March of 2020. And from that time to now, his Friday group and your Friday group has only become more popular, with everyone wanting to address it. I'm sure he gets many requests, and it's very generous of him to allow me to come and address this gathering. I hope everyone can hear, or should I speak a little louder? I think.
Little louder.
And it's a privilege to address fellow lawyers, because their understanding is what we understand, and their inputs is what we take in, and you will take in my inputs. The reason why I've chosen this particular topic is the Act, Unlawful Activities Prevention Act, though I'll refer it to as UAPA, is an old act. It was enacted in 1967. The government had forgotten about it. People had forgotten about it. But in the last 10-15 years, you will see UAPA is in the news every day in paper. UAPA has been invoked against such and such person, bail denied to such and such person, someone accused of one crime. UAPA is invoked by the ruling dispensation in a state or the central government. So there has been, so as to say, a resurgence or a revival of this Act of 1967. And just a brief background of this Act. Why 67? Is because when India went to war with China in 1962, there were various claims, particularly in the northeastern part of India, about secession of certain territories from the northeast, which China was laying claim to, and unfortunately to which some people in India were supporting that claim. So the Parliament thereafter appointed a commission which went into this question of, especially about the unity and integrity of India. And that commission made two recommendations. One was in the reasonable restriction in Article 19. It said that unity and integrity of India be included. And also asked the Parliament to enact a law in which any person claiming that a certain part of the Indian territory be ceded to a foreign nation, or any supporting a claim of a foreign nation over any part of territory of India, be made punishable as an offence. It is only in this backdrop that this act came to be enacted by the Parliament in 1967. And earlier it was a not very widely used law because it only provided for unlawful activities, which mainly provided for that support or advocating the claim of any foreign national or foreign country over Indian territory, or yourself advocating that certain part of India's territory should go to some other country. Of course, by the time of 71 war, when we went to war again with Pakistan, this act, particularly in reference to Kashmir, became and was being used as far as certain unlawful activities were concerned. So then, in its workings, there was a sort of a lull, wasn't invoked much. Punjab militancy, when Punjab militancy happens in 1980s, the Parliament somehow was of the opinion that this act was not capable enough of tackling the militancy. And why I'm giving this background, it will be necessary to appreciate what happens and why it comes into the news so much these days. And everyone is aware that during that time the central government enacted the dreaded TADA, and TADA took the center stage. First for 2 years, extended. The constitutional validity of TADA was challenged here, upheld by Supreme Court. And then it lapsed after a period of 10 years from about 87 to 97. Then there was no other act to deal with terrorist activities. Then 99, there was a change in the regime and the TADA was replaced by POTA. POTA came, and in about 2004, POTA lapsed. Once POTA lapsed, to which the ruling dispensation of the new dispensation which came, the political dispensation party said, they were against POTA, we are repealing POTA. That's the Congress party was saying this, and I'm completely apolitical, so please don't misunderstand. It was saying that we are completely against POTA and we are all for repeal, let it lapse, we don't want anything to happen. Fine. 2004 POTA lapses. But what the Parliament does, or the ruling party does of that time, is it carries out large-scale amendments in UAPA. So when you will pick up UAPA, the Bare Act, and see the amendments that have been made in UAPA for the timeline that I'm speaking of, UAPA has large-scale amendments in 2 or 3 phases. One is 2004, where terrorist activities are slipped into UAPA. They weren't earlier there. Earlier they were concerned only with unlawful activities. So you have slipped in of terrorist activities, borrowed from the earlier TADA, POTA, and brought into UAPA. Then there are large-scale amendments which start taking place in 2008. Why? Because there is that Bombay hotels where the Pakistanis entered and blasts that took place at Admiral Kasab, everyone. They found that those amendments that they made in 2004 were still not sufficient. Again, large-scale amendments carried out there. Simultaneously with that, it was the thinking of the Parliament that the state police was insufficient to deal with all these problems, particularly the kind of terrorist attack that happened in Bombay, that you have insurgents coming in, firing with automatic weapons, large-scale loss of life, bomb blasts going on. So they thought that the state police are hapless, and CBI being a body which is generally or made for economic offences, which was to investigate, because earlier they were only for prevention of corruption, also not having the wherewithal. The Parliament enacts the National Investigative Authority Act, NIA, which obviously trudges upon or intrudes upon the space of the state police and lists out in that act, in the NIA Act, a schedule, which schedule says that the NIA can investigate. It has about 10 offences that are listed, and the second or the third one of them is the UAPA. So with the timeline in place, the amendments in UAPA in 2004, in 2008, and thereafter the enactment, or simultaneously with 2008, the enactment of NIA to investigate the offences. As far as UAPA are concerned, of course, they also had the Anti-Hijacking Act, counterfeiting of currency under IPC. They had all those acts as well, which are covered by this. And then there are amendments which are done later on, in about 2018-19. Certain amendments are more so tinkering, including one of them being that an individual can also be declared as a terrorist, which was hitherto not available as far as this legislation is concerned. What is of importance is that if you see the UAPA, the first part till about section 13, which makes the unlawful activities punishable, as like I said, deals only with, as far as the question of sovereignty and integrity is concerned, and punishable is by offences by 7 years. When the 2004 amendments come, and with TADA and POTA being repealed, the question that comes is that if there is a terrorist activity which is taking place, how do you make it punishable? So the Parliament enacts section 15, or brings about an amendment in the UAPA, and says we will define what a terrorist activity is. Now, according to me, that definition of the Parliament of unlawful activities of a terrorist act is concerned is so wide, it can cover anything under the sun, any activity. Not only can it cover an activity which takes place in India, it can cover an activity which takes place even abroad, as in any foreign country. The definition is whoever with the intent does an act which is against the sovereignty or territorial integrity of India, in India or in any foreign country, by any of the following acts, which is one, carries out large-scale bomb blasts, loss of lives, etc. So if you as a person of, and you need not be an Indian, according to me, and I'm not reading the definition because it's not exactly a class or something, but if you as an Indian are going to, or a foreign national, carries out a blast in Afghanistan, for example, in an Indian embassy or a non-Indian embassy, where some Indian is involved, or says that I am against the sovereignty or territorial integrity of India, according to me, section 15 will cover it, and an Indian government can try that particular accused who is not there. So it is a very wide, and I may say a badly drafted section, because there the intent of that amendment was that you will have a provision which punishes terrorist act. It has to be an act of terror. So the definition for them, an act of terror, is that it causes terror amongst a certain society in India, which is there in section 15, it would cover. But it also went on to make two amendments. One was it made an amendment to who would carry out these terrorist acts, and according to the Parliament in UAPA, it would be a terrorist gang or a terrorist organization. So if you see UAPA, there is a difference. There are two definitions. One is a definition of terrorist gang, and one is of an organization. Now, necessarily, for a terrorist gang, it is a loose association of people for it to form a gang. It is not a gang as in which is of any formal structure. An organization, by the definition, is more formal in its nature. And this distinction, please keep in mind, because then comes an amendment which I'll come to for this part. What it does then after is to punish a terrorist act, or it punishes a membership of whoever being a member of a terrorist act, a terrorist gang or a terrorist organization is also made punishable with life imprisonment. Though it goes on to say in section 20 that whoever being a member of a terrorist gang or a terrorist organization which has indulged in a terrorist act is liable to be punished with section 20 for life imprisonment under section 20. The distinction that was not there till then was brought about in an amendment in section 35 later on, which gave the power to the government under 35 to declare certain organizations as terrorist organizations. Now, in the recent times, you all would have seen, my friends, in the newspaper, that I think PFI or one of those organizations, Popular Front of India, has been declared as a terrorist organization. This is just to reference to context to understand this. That is a declaration that the government makes under section 35, which presumes with the material that is there before it, that if you are an organization which according to the government has indulged in terrorist act, there is a schedule now to the UAPA, your organization will be put as a terrorist organization, and any person who is a member of this terrorist organization can automatically be prosecuted under the UAPA. You can't be prosecuted a time before this declaration is made of the terrorist organization. You can be prosecuted only after. One interesting matter that I was doing is regard to ISIS. Some people went from India to join the war in Syria for ISIS. ISIS got declared in 2015 as a banned organization, banned or a terrorist organization. They went in 2013. Whether it will still cover that you are a member of a terrorist organization. Karnataka High Court has its view, the appeal is pending here. But this terrorist, only the organization is put under section 35. The terrorist gang is not put under section 35. So for a terrorist gang, it becomes imperative for a government to prove that that particular terrorist gang has indulged in a terrorist act, because the word uses terrorist act. So go back to reference to section 15, which defines terrorist act, and say that this terrorist gang is one of whose membership you have. You are a terrorist gang for which there is no formal declaration. The government will have to prove, the prosecution will have to prove that this is a terrorist gang. Not only that this is a terrorist gang, but a gang which has indulged in a terrorist act. As far as a terrorist organization is concerned, the government need not prove that the organization has indulged in a terrorist act, because a declaration under section 35 subsumes within it or presumes within itself that this is an act, this is an organization which has already indulged in a terrorist act, and therefore to be liable, a membership simpliciter is liable for punishment. That is 20. It has many overlapping provisions, because again you can be prosecuted under section 38 also for being member of an unlawful organization. So you can be prosecuted under 20, you can be prosecution under 38, you can be prosecution under 39, which is supporting a terrorist organization. So all these changes were brought about by the time between 2004 and 2008 about terrorist act, terrorist organization, and it's majorly terrorist organizations and terrorist act. Now the terrorist act has not only violent acts, it also concerns economic security of India. That's why it mentions, suppose you are doing an act which threatens the economic security of India, you can be prosecuted under UAPA. That's why I started off by saying that this section 15 for us lawyers, brothers and sisters, is a very sort of a draconian provision, because any citizen, suppose you are involved in let's not even go to the extent of hawala. But suppose you are involved in any economic activities, it is easy for the prosecution to pick up or level the allegation that this particular economic activity, though it is limited to section 420 or 409 or normal case that we get and we keep filing and appearing in Supreme Court for bail or quashing or this, that this activity has threatened the economic security of India, and therefore we are invoking UAPA. Once a UAPA is invoked or a charge of UAPA is invoked, all of you know that it is draconian. It has an extended period of remand of 180 days as opposed to the 90 days maximum under the CRPC. And they have a time to file that. The provision relating to bail are difficult provisions. It is not easy to secure bail. So the citizen may suffer on account, I am saying, not of the use but the misuse of the provisions of UAPA, because the definition of terrorist act is so wide. Now, for example, UAPA may also cover a situation that in the Maoist area there is a certain band organizations which exist, and a person is a contractor who is working, who has been awarded by the government the contract of road building or any other work or putting cell phone towers. Now, his work may involve going there and working without realizing, the government realizing that, look, it involves working in a Maoist area where it is very difficult to do business. And as of commonly known, the Maoist will say, look, if you want to work here, you give us certain amount of money, otherwise we are not letting you build even an inch of the road, we will blow it up. That poor contractor gives the money. The government is open, it is open for the government to invoke UAPA against that contractor, given the definition of a terrorist act or supporting or conspiracy or abetment of a terrorist act of an organization. So section 15, whenever you have time, do go through it and try to understand it from that perspective, that it is so wide to cover any of the acts from economic security to actual bomb blasts or loss of lives or which are actual terrorist activities, but also those which may not in the ordinary parlance mean actual terrorist activities as far as we as lawyers are concerned. So one amendment that they made also was to restrict, like I said, as far as increase the age, increase the time within which charge sheet can be filed, which means your 167 right of default bail will accrue only upon the expiry of the extended period which is 180 days, which means that you are in for 6 months without charge sheet having been filed. A very interesting decision of Justice Nariman came in 2020 in that Bikramjit Singh. The question that arose before in Bikramjit Singh, and whenever you have a case on default bail, was whether it is a case which is triable by the Court of Sessions, the extension part has to be given by the Court of Sessions or an NIA court, or by the ordinary magistrate, does he have the power to extend it? I will come to that just in a moment, because before that I should mention, when in NIA, it is not only the constitution of the police force that is being done, which is the National Investigating Authority, but National Investigating Authority also can investigate only those 10 scheduled offences that exist. So when there is a demand made here sometimes that no, not CBI, only NIA. NIA is actually restricted by the statute not to investigate anything else but what it is being set up to investigate, which is the scheduled offences. Of course, it is open to the Parliament to include anything. They can tomorrow, like it was done under the PMLA Act, which also had a scheduled offence, which were very few sections. Now they've been broadened to everything under the sun, that anything which is an economic activity from 420 to 467 to 468 also can lead to invocation or PMLA. Like that, it is open to it. I hope they don't get the idea from me that they can amend it and include anything under the sun for NIA to start investigating. NIA, you must remember, is an investigation into a crime which otherwise falls within the jurisdiction of a state. You let alone the CBI, which is constituted under a particular act which was prior to the constitution coming in, the Delhi Special Police Establishment Act. You remove CBI, this is one of the few bodies which are entrusted with pan-India criminal investigation after the constitution has come. Now that intrudes upon the space of the states to investigate a crime. And the NIA Act is very peculiar because in section 6 it says that the NIA, whenever there is one of the scheduled offences which have been committed in any state or at any place, the local police will start the investigation. But it is the obligation of the local police to immediately send to the state government, which will forward to the central government, information that a scheduled offence has taken place. Scheduled offence under the NIA Act. So if there is an NIA Act scheduled offence which has taken place in any part of the country, it shall be the obligation of that particular district police officer, IO, to the state and state to the center that, look sir, this scheduled offence has taken place within this jurisdiction. Suppose it is a jurisdiction in where the state I belong to, UP, near Sultanpur, and I'm forwarding you this information that is there, please, and the state government will receive it and send it to the central government. It is not as if the central government immediately springs into action and takes it. Central government will decide whether it is a case which is fit for to be given to the NIA or not to be given to the NIA. And till such time the central government is taking this decision, it is incumbent upon the local police to carry on investigating that particular offence, even though it is a scheduled offence, and even though information about that offence has been sent to it, it will carry on investigation. If the central government decides that, look, we do not want to touch this particular this offence, the local police will carry on. If they say no, or they see any reason that yes, we would like to take over this investigation, and they move in, then all the papers from the local police will be given to the NIA, and NIA will take over. Now NIA also has in it the constitution of special courts, which are known as the NIA courts. Now NIA courts are both courts set up by the state governments and by the central government. It is not enough that the central government sets it up. The state government also have obligations to set up NIA courts. Now, apart from setting up NIA courts which are headed by a sessions judge, if there is no NIA court, then it has to be a court which is the court of sessions, and only a court of sessions will try that offence. So when the question arose before this court in that Bikramjit Singh, that suppose you are saying that it's only this extended remand can only be by NIA court, not by the magistrate. Suppose there is no NIA court. So the Supreme Court said then, upon the expiry of 90th day, if the prosecution wants an extended period for 30 days or 60 days or 90 days more, then that extension, because it intrudes into the right under 167, has to be done by a court of sessions and not the local magistrate who was empowered under the Code of Criminal Procedure to grant that remand for the period of 90 days. So that power of extended remand, Supreme Court put in Article 21, using Article 21, said that look, it is too much that this right, which was otherwise, because all 167 bails are under Article 21 of the Constitution, because the statute guarantees to every citizen the right upon the charge sheet not being filed on the 60th or the 90th day. That has been well recognized. So the Supreme Court said that look, whether NIA is investigating or NIA is not investigating, we are not concerned about it, because the amendment that was made in section 2D of the UAPA upon the NIA Act coming into, that the courts, the definition of the word court was meant to include a court set up under the NIA Act, NIA, and therefore we will deem it that this extension has to be granted only by an NIA court, or it has to be granted by a court of session. The magistrate, we are not entrusting this job to a magistrate. It is too precious a right for a magistrate to grant that in a routine manner, yes, on an application made by the prosecution, 90 days have expired. On the 89th day, the public prosecutor appears, says, yes, sir, we still require, because it's a UAPA offence, we require his custody more time for charge sheet. And it is actually an extension of charge sheet to defeat the right, and therefore they said no. And even in that case, much after the time that had passed by, the court released those accused persons on default bail. Now, it has constitution of two courts, the state and the central government, the constitutes, without which then NIA also has its own provisions of appeals, which is very interesting. If you see the Delhi Special Police Establishment Act, which is about 6 or 7 sections, not more, it doesn't provide for any other. But all these are provided under an act which is setting up a special investigative agency. It provides for its own appeals. It provides that these appeals are to be heard by a division bench. And it's one of the sections which borrows from Makoka, which is similar to, as draconian as the NIA. It also provides that in case of bail, you will have a right of refusal of bail, you will have a right of appeal to the High Court. So your bail is not filed under the normal 439 section, well, of course read with it, but under the NIA Act if it is being prosecuted for this. So the interplay between the two acts is very close, because apart from aircraft hijacking or counterfeit or any of those sections which are also there in the scheduled offences, UAPA is the section UAPA is the act which is used most by NIA. Now, I mentioned to you about this section 6. One question arose that suppose in the interregnum, the local police is investigating, and in the meantime information had been sent to the central government, and the central government gave its go ahead for investigation by NIA, but about the time being so close to each other, the local police went and filed the charge sheet. Would it vitiate the proceedings since it had already stood with the investigations stood transferred to NIA? Supreme Court in a judgment said no. The fact that the Act says that a local police can go on investigating until it is interdicted by an order of the central government, and the NIA has physically taken over the investigation, which basically means it has taken in possession the papers that are there, and thereafter proceeded, all the investigation that is done by the local police is perfectly valid. If the NIA wants to do further investigation, they are free to do further investigation, but it will not vitiate the filing of the charge sheet or the investigation that had been done by the local police, even though at that particular point in time, the central government had in fact taken a decision that the matter be transferred to NIA. So when you read the Act, NIA is not only procedural, the Act is not procedural, it is substantive. You have a right, though under UAPA, the accused has a right for extended remand for it to be under an NIA court. If the NIA court is not there, it has to be a court of sessions. Second, the NIA will try or investigate is not an absolute right under Section 6. It should come from the central government's choice, and there are no guidelines. It is just pick and choose that the central government can say, look, I am not interested in a particular bomb blast that has taken place, let's say somewhere in Tirupur, no, or Cochin, no. I am interested in a bomb blast which has taken place in Patna. Yes, NIA will investigate that, but the other one we will not. But both will be prosecuted under UAPA, that's a given because that's the Terrorist Act. Both will be prosecuted under UAPA, but both will have the question of extended remand, whether investigated by NIA or not, to be decided by a court of session or in the absence of court of sessions in the absence of an NIA court. So make no mistake that the NIA court comes into play moment UAPA is invoked as far as extended remand is concerned. If it exists, it may exist in a particular district, or it can exist for 3 or more districts, 4 or more districts. It can exist like CBI courts in Uttar Pradesh. One is in Ghaziabad, the other is in Lucknow. In that sort of a way, you have a sort of a trans-state, territorial state courts that are established. So there it's not enough that it is an NIA investigation. What you have to see is that it's a UAPA investigation, or an investigation under an offence under UAPA. Now coming back to UAPA apart from these aspects had an amendment in 2019 or 20, I think 19, before the pandemic, that an individual also can be declared as a terrorist. Up till now, it starts with an unlawful activity by organizations, which is up to section 1314. Extends to Terrorist Act in 2004, extends a little more to other terrorist organization 2008 and 2012, and now we've done a full circle that even a terrorist as an individual, that is Siddarth Dave, can be labeled by the central government as a person who is a terrorist, and his name can be put in the schedule for a terrorist. So if you see the schedule of the UAPA, you will come across this, that it has both organizations and terrorists, which are individual terrorists. Of course, the first part of unlawful organizations, which is in the first part, the Parliament then thought fit to have a board before whom the review is filed, and before whom, which is generally headed by a judge of the High Court, like you had even in that coffee posa. You have a judge of the High Court which reviews the material whether to uphold as far as unlawful organization was concerned. Likewise, for terrorist organization also, you have a board headed by a sitting judge to be nominated by the concerned government in consultation with the Chief Justice, who will head and review the material that is there for the purposes of whether this organization falls within the qualification of being declared as a terrorist organization. So thereafter, that means that if an organization is just declared as a terrorist organization, it is not sufficient. That organization can go before that tribunal which is set up, normally headed by one single judge, I think, unlike the NDPS, which is by 3 judges, that one judge to give its materials and say, sir, we are not a terrorist organization, we are involved only in these religious activities, we have not ever indulged in a terrorist act. Now mind you, that terrorist organization, it presumes, the notification presumes that has indulged in terrorist act. So the government has to produce before the tribunal material showing that this particular organization with whom we have notified as a terrorist organization has in fact indulged in terrorist acts. So we go back to 15 and the government has to lay the material before the tribunal, and it is up to the organization to challenge it. See, if it's a foreign organization, like if you have in that Babbar Khalsa or KLF or one of these organizations, they are really not bothered about whether I'm declared as under an Indian law, because they don't operate in that sort of sense here. But suppose you have some other organization like this Burning Question or PFI, which organize at a level in India, Popular Front of India. So they will certainly have their say. It is not as if it's all in the dark and this is completely arbitrary in the hands of government, that whoever we declare is assumed to be a terrorist organization. No. The government will lay the material and the organization will counter that material, and the judge will come to a question whether it is or it is not. That decision is also subject to judicial review. You can file a writ and say that this judgment was wrong, this judgment, there is no material, and a court later on can pronounce on it and say, look, the material is not sufficient to declare you as a terrorist organization. We strike down this notification saying that so and so organization is a terrorist organization. Likewise, even for an individual terrorist, which they have named some like that Mazur, Azhar Mazur and all those in Afghanistan and Pakistan, etc. They have named them. So they also have a right, but I doubt they are going to come to India and say that, don't declare us. So the interplay, please remember, is at a procedural level. It is at a level more than procedural, at a substantive level. And for these two acts, whenever you are reading or you have a matter which concerns these two, make sure that the argument comes that if you see that, oh, this is a UAPA invoked, did the government in Madhya Pradesh, suppose it is in Morena in Madhya Pradesh, UAPA invoked, did the state government send information to the central government saying an act under UAPA has been invoked, and did the central government decide whether it should take it over or not, because it is absolutely mandatory. What it does, it sort of, in a way, you can use it as a safeguard against false invocation of or wrong invocation of UAPA, against when you have matters which have clients which have been incarcerated under UAPA, to say that, look, that this was not done by the state government. Obviously, this is a false case. They did not want the NIA to investigate, and therefore you can have some legs to stand on in a court. Otherwise, in a UAPA matter, it is very difficult, one, to get bail. It is very difficult to quashing. There is no question whether it is, once it's invoked, that I don't think any court will generally not touch it, and even bail becomes very restrictive, and therefore we have to come out with our own ingenious arguments to challenge it on various grounds, because there are times when, like I said, innocent people also are put behind bars under this UAPA. So that broadly is the interplay between UAPA and the NIA. So I think that should cover the topic. Thank you. Please.
Thank you very much, Davyaji. Very elaborately you explained everything. Crystal clear now. Now question answers. Please, any questions, please, remove that.
So how do you reconcile when the conflicts comes with the state law as well as the process which is pending before the central government to invoke the NIA?
That's very good. That's a very good question.
Not necessary.
Okay. Because the conflict will come if the state government has not sent. That means you can argue that investigation is vitiated and the invocation, because the state government is trying to hide anything. Problem is the Supreme Court judgment which says that it is valid till it takes over. So the conflict really comes at a time when the central government decides to take over a particular investigation, and it's investigation specific. If the central government, if the state government has sent the information that this offence has been committed, we've invoked UAPA, and the central government has not done anything, then of course there's no question of conflict. The state government will continue investigating it. But once the central government comes in, then the state government has to cede way to the central government completely. All investigation, and the words, the expression, physically the investigation has to be transferred. Taken over is the word used, that they will go to that particular police station, or they will go, or that police station, all the papers will come, and it will be, and the state government's investigation will be subsumed by the central government investigation. There is no scope. Central government prevails whenever it decides to investigate. If it doesn't decide to investigate, then the state investigation will continue.
Any question more you want? Backside, any question? Yeah, please. No, backside. You want to ask? Yeah, please.
So I have a follow-up question based on the state's investigation part. So you mentioned another pan-India investigation agencies, the CBI. It still needs the state's consent to investigate any crime. We have no such power in the NIA. So do you think it sort of attacks the federal structure, because police and public order fall under this too? So the CBI will always have to ask consent, and a lot of states have taken away the general consent that's been given. So
yes, that's very interesting. She's right. NIA does not have any consent that is required from the states. It is an act which is bulldozed by the central government on the states, because they said this involves terrorist act. Terrorism, for the reason why TADA was upheld, was because it affects the sovereignty and integrity of India, which vests in the central government entirely, for the protection of which is the 91, that Kartar Singh judgment. And therefore, but as far as investigation is concerned, it was challenged surprisingly in 2012 before Maharashtra, in the Bombay High Court. It was challenged by Pragya Thakur that this is violative of the Constitution. Bombay High Court upheld the constitutional validity of it, and thereafter it has not been challenged here up till now on this ground that it makes inroads into this. The other aspect of Section 6 under the Delhi Police Special Establishment Act, which requires a state consent, unless the CBI investigation is ordered by a court, whether you have consent or not, they said it doesn't apply to courts under that Democratic Rights versus West Bengal, but which requires, and can you then investigate, the CBI investigate within the territory of that state? That question even if it's withdrawn, can they investigate prevention of corruption cases? Can they still investigate people who are in central government employment, state government but deputed to central government, their own officers? Even that is pending consideration here, including the constitutional validity of CBI is also pending in Supreme Court. The Guwahati High Court struck it down, said this is nothing like the CBI, but it's pending consideration and hasn't been heard up till now. But yes, this doesn't require it, and it will be a very interesting test to raise that how the NIA Act destroys or goes against the very federal concept which is ingrained in the Constitution, and it is one of the basic structures of the Constitution. But as of now, there is no permission required under the NIA Act for investigating UAPA offences.
Any more questions? Yeah, I ask Shekhar Preet will give vote of thanks. Please.
Thank you, sir. We are enlightened in such a way. It's such a complex matter you have explained, and now we understood at least the fundamentals with not so much intricacy. And we have waited long for you, and now it justified after hearing you. Thank you very much.
Thank you. Thank you, everyone. Thank you.
Where is the register? You want to ask? Where is the register? Please register.